todo el mundo, bienvenido a mi canal. Yo me llamo Sidey. Soy una abogada afro-latina, licenciada y practicando las leyes criminales, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a hablar del caso. Espérate. Vamos a seguir hablando del caso de Sean Diddy Combs. Si quieren más videos en español, nada más dime allá. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latina criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. Listen, today we're going to revisit a case that we've already talked about, but the sentencing for this case is coming up, and I just wanted to share some very important developments in this case with you guys. I heard that relatively recently, the parties, as in the attorneys in this case, were before the court yet again, and they were arguing one of defense's motions for either an acquittal or a new trial. I just want to share all of this with you guys. I want to scream it from the rooftops, from the heavens. I want to shout it out. I want to do all of that because this is going to be a rather interesting video. If document review is not your thing, I am telling you right now, go ahead and click off. But for this video, and for the people who want to review the documents with me, we're going to get into the motion that was filed by the defense, the response by the United States government, the reply to the response from the defense, and what exactly happened at that hearing before the court. Without further ado, this is the case of Sean Diddy Combs. If you guys will remember, Diddy's trial was a federal trial, so it was held in the federal courthouse in the Southern District of New York. At the conclusion of the trial, the jurors convicted Diddy of two, I would say, lesser counts, but not lesser included, and there's a difference. Lesser included counts are included lessers of a count, right? And lesser counts are just counts that aren't as severe. Does that make sense? So for example, they convicted Diddy of 2 charges of transportation for the purposes of prostitution. Those aren't lessers of the RICO Act. They're not lessers of any other charge that he was charged with. They're just less serious in terms of penalty than the other charges. Or for example, we can do DUIs, right? A lesser included of DUI would be DWAI, or driving while ability impaired. And I want you guys to fact check me because I know it differs from jurisdiction, but where I'm licensed to practice, that's how it works. Or we can do like assault in the first degree. A lesser included of assault in the first degree is assault in the second degree, right? So basically what I'm saying is he was convicted, but not of the most severe charges. But regardless, let's talk about what happened after his conviction. So he was convicted on July 2nd of 2025. After that conviction, and a few days later, on July 30th of 2025, Diddy's defense team filed a specific motion requesting some sort of relief from the court. We're going to get through that together today and right now. So Diddy's legal team filed a renewed motion for judgment of acquittal, or in the alternative, a motion for a new trial, as to the 2 charges that Diddy was convicted of. The reason I think that's a little bit interesting, and I've told you guys this before, motions for judgment of acquittal are typically raised in the middle of trial and after the prosecution finishes their case in chief. The fact that they've renewed their motion at the conclusion of the trial is not all that surprising. I feel like Diddy's team has been on top of things and they've been filing motions and requesting certain reliefs from the court. So I'm not surprised to see that they filed it here. But let's get through exactly what their arguments were to the court and why they think that Diddy deserves an acquittal, or in the alternative, a new trial. Diddy's legal team kind of breaks down their main arguments into 3 specific points. The first, they're saying that Diddy didn't really transport anyone for the intention or the purpose to engage in prostitution, nor did the government show that. Second, they argue that upholding these convictions would violate Diddy's First Amendment rights. And third, they argue that prejudice would just ensue should the court just let these convictions stand. Let's go through them one by one and see what their specific points are. Per the first paragraph in their arguments section, there was insufficient evidence that Mr. Combs transported anyone with the intent to engage in prostitution. It further elaborates. Mr. Combs was convicted of knowingly transporting an individual in interstate commerce with the intent that such individual engage in prostitution. The 2 counts of conviction that require the prostitution was the purpose of interstate transport. The Mann Act does not define the term prostitution. A host of serious constitutional problems would be presented if the statute were interpreted to cover the conduct at issue. Performances in which adult male escorts and Mr. Combs' adult girlfriends engaged in consensual sexual activity while he observed. The evidence showed Mr. Combs experienced these performances not as a typical John, but rather as a voyeur who filmed the performances. To avoid these constitutional concerns, the statute should be narrowly construed to apply only to defendants who have a commercial motive, or at the very least, only to Johns who pay a prostitute to have sex with the John. Alternatively, even if prostitution includes paying money to watch other people have consensual sex, no reasonable juror could find the trial evidence sufficient to prove, beyond a reasonable doubt, that Combs intended to pay the escorts or entertainers for sex as opposed to their time. Okay, so they go on to further elaborate and make additional arguments, but I'm going to stop here to just give you guys my opinions. As the statute is stated and as it's written and as it was even interpreted by defense here, Diddy was convicted of knowingly and intentionally transporting people through interstate commerce with the purpose of the person participating in prostitution. Man, that's a tongue twister. I think that the jurors got it right. Point blank, period. I think that the jurors got it right. If we are looking at that definition as a whole, I understand that the argument lies with the fact that people are saying, well, these are adult girlfriends, and they were voluntarily engaging in consensual sexual intercourse at Diddy's direction, instruction, what have you. Okay. Prostitution is the paying of money for goods, services, or what have you of a sexual nature, right? All the evidence at trial showed that Diddy was paying these adult male entertainers to sleep with his adult girlfriends. So it's not necessarily that he was transporting his girlfriends. In my mind, it's that he was flying out these adult male entertainers. So transporting them through interstate commerce, right? And giving them money for sexual intercourse with his girlfriends. And that is prostitution. I understand that some folks might not agree with me, and that's your prerogative. I'm just trying to explain where I don't think that defense really hit it, at least not for me, on this particular argument. But let's carry on and see what else they have to say. The second section says, upholding the convictions would violate the First Amendment. It further elaborates. The evidence at trial showed that during the freak-offs and hotel nights, Mr. Combs directed and recorded live sexual performances that he would later watch with his girlfriends. The trial record thus demonstrates that Mr. Combs and his girlfriends arranged these get-togethers not just for the voyeuristic purpose of sexual arousal and gratification, but also to capture sexual performances on video in a manner similar to an adult film producer. The Mann Act cannot be enforced in these circumstances without violating Mr. Combs' First Amendment rights. Okay, so let's go ahead and talk about this. We didn't talk about the Mann Act originally in the first portion. I will let you know that this motion is riddled with defense's definition of what they feel the Mann Act should be interpreted as, which is not wrong. There's nothing wrong with that. I think that as lawyers, we take a interpretive, I guess, a different way to interpret things, right? So you can ask a million lawyers the exact same question and get a million different answers because we're interpreting the review or the actual letter of the law to mean different things. And it doesn't necessarily mean that anyone is wrong per se. It just means that different arguments can be made. So the Mann Act, and I don't know if we talked about this because the Diddy series was a long time ago, but long story short, the Mann Act basically just criminalizes at a federal level transporting people through interstate commerce for the purposes of prostitution or sexual gratification. What defense is arguing is, which is not untrue, that the original purpose of the Mann Act was to stop against human trafficking, right? I think that where defense misses the mark for me is the fact that as we grow and as we evolve as a society, definitions and such change. Laws change. The intent behind it, although originally so back in the 1900s when the act was enacted, changes, right? And so there's no prohibition on the prosecution from prosecuting someone who isn't necessarily engaged in the traditional definition of human trafficking, as we see here. And I just think that's what they did. Defense doesn't necessarily have to agree with it. I see the arguments that they're making and I understand them, but I just don't know how much leeway the court is going to give for this form of interpretation. Does that make sense? But let's carry on. Let's go on to argument 3 and see what they say there. Argument 3 says, at a minimum, a new trial is required due to spillover prejudice from evidence that would have been inadmissible had the Mann Act counts been tried alone. In the alternative, if this court does not grant acquittal under Rule 29, it should grant a new trial under Rule 33 due to spillover prejudice from the RICO and sex trafficking counts. As the Second Circuit has held, considering a claim of spillover prejudice, quote, if the RICO counts fail, prejudice on other counts is highly likely. The reason for this is straightforward. RICO charges allow the government to present a wide variety of evidence that would otherwise be inadmissible and highly prejudicial. The likelihood that such evidence has an impermissible spillover effect on other counts is high. This case starkly illustrates the point. To try to prove the sex trafficking and RICO charges, the government introduced tons of inflammatory evidence. None of this evidence would have been admissible if the Mann Act counts had been tried separately. Although the jury rejected 3 of the government's charges, there remains a substantial likelihood that its decision to convict on the other 2 charges was influenced by inflammatory evidence. A new trial on the surviving Mann Act counts is therefore warranted. Okay, so I try to give credit where credit is due, and I feel like I do a pretty good job, or at least in my mind, of, pointing out goods and bads in either side. It doesn't matter the side, defense and prosecution, right? I think that this argument is silly, but I understand why they made it. The reason I think it's silly is this, right? If we haven't talked about this already, there are different types of joinder and severances that can happen in different trials, meaning, and I don't know if it was filed already and just rejected, but that would just prove my point even further. But meaning, had the defense attorneys in this case been so concerned about prejudice that would spill over from those counts being tried together, they could have motioned the court for separate trials as to those 2 charges or those numbered charges and the remaining charges. Right? Now, I don't know if they did it, but let's assume they did, and the court rejected that argument. I think that's even more basis that the court's going to reject the same here. Okay? The prosecution is allowed to present whatever evidence it decides to present, so long it's not barred by any sort of other circumstance, court order, what have you. As long as the proper procedural steps are taken, the prosecution can present the evidence. So I understand that the defense attorneys in this case are saying, well, hey, judge, they acquitted him of the more serious charges. And because everything was being charged jointly and tried jointly, some evidence that was more so trying to lean to prove the more serious RICO charges was admitted and might have influenced the jurors' decisions on the less serious charges. We need a whole new trial to rid the defendant of all this prejudice. I just think that's a fallacy. But go ahead and let me know what you guys think below. I'm not going to go too much deeper into the defense's motion because we need to talk about the government's response. In their response, the government states that the court should deny the defendant's motion for judgment of acquittal based on quite a few factors. First, the defendant's statutory arguments are not properly asserted under Rule 29. Second, the Mann Act does cover the conduct of the conviction. Third, the defendant's purported First Amendment concerns are meritless. And 4, there was sufficient evidence for a rational jury to find the defendant guilty of the counts of conviction. Before we get into everything individually, do you see how all the bulleted points that I just went through with you kind of mirror, if not add some sort of credence to the arguments I just made to you? I'm not buying a lot of Diddy's defense team's arguments, but let's carry on. In the government's preliminary statement, they state, the government respectfully submits this memorandum of law in opposition to the defendant's renewed motion for judgment of acquittal, or in the alternative, a new trial. The defendant, following a conviction at trial on 2 felony Mann Act counts, advocates for the court to narrow the scope of the Mann Act to exclude his own criminal conduct on the grounds that, among other things, the statute is unduly vague, violates his substantive due process rights, and violates his First Amendment rights. The defendant further contends that the record at trial fails to support his counts of conviction. The defendant is mistaken as a matter of fact and law. As an initial matter, because several of the defendant's Rule 29 arguments addressed alleged constitutional issues and are untethered to the sufficiency of the evidence, they are not properly raised in the present motion and can be rejected on that basis alone. Even if that were not the case, however, the defendant's arguments fail. While the defendant may wish to limit the provisions of the Mann Act to suit his own purposes, the terms of the Mann Act are unambiguous, contrary to the defendant's arguments, whereas here, the text of the statute is clear. The doctrine of constitutional avoidance is inapplicable. And even if the court were to consider applying the constitutional avoidance canon after conducting a textual analysis of the Mann Act, there are simply no constitutional concerns to avoid. The Mann Act is not unduly vague, nor does its provisions run afoul of substantive due process or pose federalism concerns. Equally, the defendant fails to raise any legitimate First Amendment concern, since his conduct is clearly not entitled to First Amendment protection. Further, at trial, there was ample evidence to support the jury's convictions. The defendant masterminded every aspect of freak-offs. He transported escorts across state lines to engage in freak-offs for pay. He directed the sexual activity of escorts and victims through freak-offs for his own sexual gratification, and he personally engaged in sexual activity during freak-offs. There was more than a sufficient basis, viewing the evidence in the light favorable to the government, to support the counts of conviction. Finally, the defendant fails to present any basis for a new trial. The defendant's retroactive misjoinder argument is without any merit and should be summarily dismissed. There is no precedent or legal basis for a new trial based on retroactive misjoinder following a split jury, and the defendant suffered no impermissible prejudice. Accordingly, and for the reasons stated below, the defendant's motion should be denied. So after reading that, what do we learn? That I'm right. No, I'm just kidding. But honestly, okay, I love when I interpret something for you, and then I'm able to read it from other attorneys who are saying pretty much exactly what I just said. I love that because I don't want to be your law. I don't want to be your law. I want to be your basis of knowledge, and you can go out and look up the story yourself. What they're saying here is basically what I already said. If defense did not previously raise prior to trial the fact that they wanted these charges to be severed from one another, you don't have a basis to raise it now just because he was convicted of some and not the others. That's not proper. What they also said was something I already said too. They said it in more, I would say, inflammatory terms. But basically what they're saying is Diddy wants the Mann Act to not apply to him specifically because it would be beneficial to him for it not to apply. But it does apply, and it does apply to his criminal conduct. Thus, the convictions are appropriate and they should stand. I think that the government's position is more in line with my own thought process on this case. I don't believe that Diddy's legal team raised any sort of basis, in my mind, for Diddy to get a new trial or for the convictions to be set aside either. But let's go ahead and take a look at defense's reply to the government's response. See if they can change my mind on some things. In their reply to the government's response, defense states, Combs's arguments are properly before this court. Defense further states, the government did not prove Combs transported anyone intending to engage in, quote, prostitution. Defense further states, the government's First Amendment arguments are meritless. And finally, they state, at minimum, a new trial is required due to spillover prejudice from evidence that would have been inadmissible had the remaining counts been tried alone. So basically, the format of a reply to a response is just reiterating your original arguments, but possibly adding in some additional information that might combat what the person was arguing in their response to your first motion. Does that make sense? So basically, if you heard in the arguments that they're making in this reply to the government's response, they're basically just saying the same things, probably adding a little bit more credence to their arguments and giving the court a little bit more to consider. But they're basically just reiterating their original talking points or their original arguments. I am not going to go through all of that because that's going to make for a very lengthy video. I will just say, we'll see what happens. It's my understanding that Diddy is scheduled to be sentenced on October 3rd of this year, 2025, which is literally right around the corner. I also know that in their last hearing, I don't know the date of it, I'm so sorry, but in their last hearing, defense and the prosecution were arguing these motions and their responses, their replies, what have you. The court, so Judge Arun Subramanian, advised the parties that it would take the issue under advisement, which is not uncommon in federal court. Pretty much everything is written in federal court, like responses, replies, what have you. Pretty much everything is written. So it's not really uncommon or surprising for the court to want to take something under advisement because it'll issue a written order. When that written order comes out, here's my prediction. I believe that the court is going to deny defense's motion. I do. I don't believe that defense made a good enough argument as to why an acquittal of the charges he was already convicted of is warranted, nor do I feel like defense made a new argument or any novel argument or any, I guess, valid argument as to why a new trial is warranted. I could be wrong, but that's just my prediction for right now. We will find out together. Like I said, October 3rd is when the sentencing is set to occur. I hope to have another video out for you guys about the sentencing at some point past then, or shortly past then. I wanted to do a different format of video because there's so many documents and so much interpretation and so much that just can be confusing. And I just like reviewing stuff, but I also don't want to bore you to tears. So that's why I try not to do that in every single video, just have full document review videos. But go ahead and let me know down below if you like this format. Did you enjoy it? Did you enjoy this video? Are you excited for Diddy's sentencing? And not excited because we're celebrating anyone's downfall, but just excited to see the outcome of the sentencing. What do you think the court will do? What do you think the court's going to rule on these motions? What do you think the court would sentence Diddy to if it denied the defense's motion? Just let me know all of your thoughts down below. As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.